You are watching PR English Shorthand Dictations YouTube channel.
This is English Shorthand Dictation number 359 and the dictation speed is 100 words per minute. Ready? Start. Honorable Speaker, Sir, I am thankful to you for the opportunity that has been offered to me to speak on this small amendment bill. Sir, when this Parliament discussed the 42nd Amendment, it was said that the legislative competence of the Parliament cannot be questioned in the court of law. This triggered the controversy. Ultimately, it was settled down later by virtue of the 44th Amendment. The legislative capacity of Parliament could not have been questioned in those days. Now, Parliament's capacity of legislation has become a mockery through this bill. I do not know how this bill was drafted without giving any due care for the legislative competency of this Parliament. Ever since this government came into power, Parliament is being misused. Most of the laws under state subject were brought here for amendment, encroaching the state power. Ultimately, the state autonomy and cooperative federalism became a laughing stock. It is a small bill, but I am not able to understand the way nationalism was put up everywhere, even in the Advocates Act. The Honorable Minister talks about colonial law. In 1879, the provision was there. You want to repeal it. But by way of repealing it, you are introducing the same section in the new law. What does it mean? Is it not the same colonial law? I am not able to understand the rationality of the government behind this amendment. What happened to Article 356? Article 356 says that a state government can be dismissed on the recommendation of the governor or otherwise. The word otherwise was used by the president when the Tamil Nadu government was dismissed without the governor's recommendation. It is such a dangerous provision for Advocates Act. You are putting the same word otherwise here. Nobody can say how it is going to be used or misused. This House many times has discussed corruption at length. The Prevention of Corruption Act has been periodically amended, which says that not only the receiver but the giver of the money is also a culprit under the Act and he has to be convicted. The tout is going to be eliminated and given imprisonment or penalty. Does it not mean that the person who is giving money is also liable to punishment? What type of justice are you rendering to A and B between whom the money is exchanged? So, the very purpose of the Prevention of Corruption Act itself is defeated here by the way in which the bill is drafted. For the first time, I have come across a bill which has been submitted to Parliament in which the objects and reasons were not at all given. For what purpose are you going to introduce this amendment? I want to know whether the Bar Council of India is going to be consulted when a person is going to be listed as a tout, what will be the role of the Bar Council? Sir, former Chief Justice of India, Justice Bharucha, a decade ago, said in the open meeting on the eve of his retirement that 20% of the judiciary has become corrupt. He made an open statement. If a litigant is having a case in a particular court, how will he know that the judge comes under that 20% or the remaining 80%? So, you want to keep the entire judicial system clean, but for a small matter, you are not able to draft a clear law to serve the purpose. What type of purpose is it going to serve? Ignorance of law is not an excuse. That is a legal maxim. A person cannot claim that he did not know the law. What about the society? Still, 30% of people are illiterate so far as law is concerned. 70% of people are unaware of the legal system. If you want to regularize the system of touts, you should frame some reasonable guidelines by permitting or not permitting them. A healthy discussion must be there in all the forums, including the Bar Council of India. After the examination done by the Bar Council of India or Supreme Court judges, a man has been designated as advocate on record. A senior advocate designated by the High Court and the Supreme Court cannot be advocate on record. Advocate on record is afraid. Senior advocate is afraid. Who is approaching the senior advocate? Is it the litigant? No, it is advocate on record. The role of the advocate on record becomes quite similar to that of a tout as far as the senior advocate is concerned. So, a judicial system needs some middlemen to bypass every loophole in the judicial system. The important question is whether that must be eliminated or that may be regularized with a rational application. That is a question before this House. I think that this bill is having no meaning at all because you are just mechanically transporting a section which is available in 1879 Act to the new Act without application of mind. What type of exercise has been done by the government? What inference has been drawn from this 100-year-old law? Is this provision essential? Is this provision workable? Has the practicality of the provision been applied? Nothing has been done by this government. But you want to remove the corruption in the name of Narendra Modi, starting from small bill up to a big bill. So, my only submission is this: do not make this parliament a laughing stock. Do not do the meaningless exercise for which the competency of the parliament is undermined. I request you to revisit the law, draft carefully, and try to make a law which is workable in the judicial system.